Good day, Crime Talk aficionados. We have another great show for you as we head into the weekend. First, Nancie Guthrie, safe but scared. Karen Reed seeks some help from the court after, let's just say an email that shouldn't have gone out. A convicted murderer, Wade Wilson, he sets his sight on the Supreme Court in regards to the death penalty. A Las Vegas educator, I wonder what he was arrested for. We've got this day in legal history. Our quote of the day has to do with freedom, our dumb criminal, and yes, can you believe it? It's already been a month, so we have the unboxing of the Battlbox. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below, and make sure you hit that bell for notifications. And yes, you can check us out on any of your favorite podcasting apps. And I was looking at the stats just today on the podcast itself. Just the audio, not YouTube. We are almost at 3 million downloads when it comes to podcasting apps. Amazing. Absolutely amazing. Thank you all. Very humbling. Very humbling. All right. Before we get to the docket, let me remind you, go to crimetalksearch.com, sign up for that background subscription service today. And when you do, you'll be able to do as many background searches on anyone here in the United States that your heart desires. So if somebody is coming into your life, maybe it's someone you're dating, maybe it's the new friends your kids are hanging out and you're not really sure about their parents, go check them out. Get that subscription. You get a report prepared while you wait. It's going to come to you and you're going to get their social media presence, emails, phone numbers. You're going to find out if they have a criminal history. Are they married, divorced? Are they on a sex offender registry, for goodness sake? Go to crimetalksearch.com. You'll be happy that you did. Think about it, ladies and gentlemen. Companies do background searches on people that they're going to be working with. Why would you not do it on people that are coming into your life? Absolutely. Go do it. All right, let's go ahead and open the record for Friday, February 6, 2026. And first on the docket, the ransom note claims Savannah Guthrie's mother, safe but scared. That's right. Nancie Guthrie, the 84-year-old mother of Today's Show host, co-anchor Savannah Guthrie, who was abducted from her Tucson area home in the early hours on Sunday of last week, sparking a high-stakes investigation now in its 6th day. So police have come to the conclusion that Nancie Guthrie, who has limited mobility and relies on daily medication and a pacemaker, was last seen about 9:45 p.m. Saturday after her family dropped her off following a dinner at her daughter Annie's house. Her pacemaker app lost connection with her phone at approximately 2:28 a.m. Sunday, and her doorbell camera was disconnected around the same time. Blood spatter on her porch later tested positive for her blood and DNA. Now, a neighbor reported seeing a suspicious unmarked white van parked on the street several days before the disappearance, describing it as a full-size vehicle without any company markings. And the chilling ransom communications, the ransom note sent to media outlets, including TMZ and local Tucson station KOLD, have added urgency and credibility to the case. One note sent to TMZ stated that Nancie is safe but scared and aware of the kidnapper's specific demands. It included private details such as the exact placement of her Apple Watch and a damaged floodlight at her home that were not publicly known at the time, leading journalists and police to take it seriously. Now, the demand reportedly includes millions of dollars in Bitcoin, with initial deadlines that pass without resolution and a follow-up Monday deadline as well. Now, the family has received at least one note directly and released emotional video pleas urging the abductors to make contact and provide proof of life. In one Instagram video, Savannah's brother, Cameron, said the family is waiting for contact and needs to know their mother is safe before proceeding. Savannah and her siblings emphasized they will not rest until she is returned. And the Pima County Sheriff's Chris Nanos appeared visibly moved during a February 6th interview on the Today Show, choking back tears as he discussed the case. "You have to have hope. We're going to find her," he said. "This is somebody's mom. Now, the FBI has joined the Pima County Sheriff's Department in the investigation, offering a $50,000 reward for information leading to Nancie's safe recovery or the arrest of anyone involved. Now, police believe that she may still be in Tucson or the local surrounding area and continue to treat the case as an active abduction. No suspects have been publicly identified or ruled out, though every person connected to the case remains under scrutiny. Now, one report citing law enforcement insiders suggests Annie Guthrie's husband, Tommaso Cioni, the last known person to see Nancie, has emerged as a person of interest, with investigators towing vehicles and searching properties for digital evidence. Now, Sheriff Nanos has stressed that labeling anyone a prime suspect prematurely could be reckless. Now, obviously, we're not saying that anybody is a suspect, and even if they were, they would be given the presumption of innocence. Now, separately, a California man named Derek Kallela was arrested for sending a fake ransom text demanding Bitcoin, underscoring the difficulty of verifying communications in such a case like this. What's real and what's fake? Obviously, the disappearance has drawn wide attention, and even President Trump publicly offered full federal resources and expressing prayers for the family. And Savannah Guthrie has stepped back from her hosting duties, including the planned coverage of the 2026 Winter Olympics, which basically has started, to focus on the search. Now, as the investigation continues, officials and the family are urging anyone with information to contact police. The $50,000 reward remains active in hopes of bringing Nancie Guthrie home safely. We're learning more and more. Clearly, that police went back to the house of Miss Guthrie, Nancie Guthrie's house, at some point. Could it be because they did, in fact, get the note and say, hey, we staged various things to show credibility as to what was in the house and where things are placed? It's going to get interesting. I think this is going to come to a head probably over the weekend. We'll see. And I hope Nancie Guthrie comes home safely. Next, Karen Reed seeks a little help from the court for that little email she sent out. So in a recent development in the civil litigation surrounding the death of Boston police officer John O'Keefe, the civil defendant, Karen Reed, has petitioned the court to address an inadvertent email disclosure that her legal team argues compromises attorney-client privilege. Now, Reed, who faces 2 criminal trials for O'Keefe's alleged murder, saw her first proceedings end in a mistrial. Obviously, Karen Reed had 2 trials as it related to the alleged murder of John O'Keefe. The first trial ended in a mistrial, and the subsequent trial, she was found guilty solely of operating a vehicle under the influence while being cleared of all other accusations. Because, yes, the jury believed she was drunk, but she didn't back into her boyfriend, even though she said she did. I know. A lot of people think she's completely innocent, but let's wait and see. Prosecutors had contended that Reed struck O'Keefe with her automobile and then abandoned him in the freezing conditions outside a residence belonging to acquaintances. Conversely, her defense persisted that individuals within the home were responsible for his death and orchestrated a scheme to implicate her. Now, though the criminal proceedings have concluded, civil actions persist, and O'Keefe's relatives have initiated a wrongful death suit against Reed and the establishments where the pair consumed alcohol prior to the incident. In response, Reed has countersued, targeting those she claims are the actual perpetrators, along with law enforcement officials involved in the investigation. Now, the current issue stems from an email exchange on December 16th of 2025. One of Reed's lawyers replied to correspondence from O'Keefe's family's attorneys, blind copying Reed, and this response refuted claims that Reed's representatives had disseminated evidence conflicting with her sworn statements. So basically, they submitted an answer, then Reed chimed in, unbeknownst that she had replied all to everybody, thinking that was just going to her attorneys. And yes, they conflicted with the official answers that they gave in regards to the responses. That's interesting, isn't it? Anyway, shortly thereafter, Reed replied to the message, but unintentionally hitting reply all, thereby sending it to all the participants. According to the motion submitted by Reed's attorney, she was unaware of her blind copy status and believed the response was directed exclusively to her attorneys. Upon discovering the error, her team promptly contacted the opposing side, requesting deletion of the message and saying that it should be ignored. Attorney-client privilege. Oops. And let's face it, attorneys, everybody has done something like that and usually say, hey, that was confidential, just delete it. But here, when they know the response was different than what the attorneys did, it gets a little trickier. So, O'Keefe's family's legal representatives assert that the email includes pertinent factual details relevant to the case, which they reviewed before recognizing the accidental transmission. They argue against disregarding the email. Reed's counsel is now urging the court to mandate the deletion of the email and its exclusion from the record or evidentiary use, invoking attorney-client privilege protections. The opposing party counters that such privilege was forfeited through the reply all action. Now, the email's specific content remained undisclosed in public filings, with a notation indicating it is available for private judicial review in chambers. The episode obviously shows the complexities of all the electronic communications in legal matters these days. And obviously, it's interesting because apparently the attorneys for Miss Reed said, here's answer A to your interrogatories, your responses. Karen Reed then responds to her attorneys, thinking it's something only going to her attorneys. Apparently, it's contradictory to what her attorneys have turned over to O'Keefe's family. So now O'Keefe's family knows it. But here's the greater issue. If Karen Reed's attorneys know that there's a different answer than the truth, they need to supplement their responses to the interrogatories. That's where it gets tricky. Right? Civil, it's a little bit different than criminal. Criminal, your client has a right to remain silent. And, he may have told you, hey, I did it. And you still can make the prosecution prove their case beyond a reasonable doubt. In the civil, you don't get that protection, so to speak. You, as the attorney, have to be truthful to the other side. You can't give false answers. So it's a tricky ethical quandary Miss Reed's attorneys are walking into. Although, it's not like they haven't had to deal with that before. Next, Wade Wilson. Remember him, the convicted murderer? Well, he's setting his sights on the United States Supreme Court. So in a concise proceeding before the Florida Supreme Court on Thursday, legal counsel for death row inmate Wade Wilson announced their intention to escalate his challenge against his capital sentence to the nation's highest court. Of course he will. Now, Wilson was convicted for the 2019 slaying of Kristen Melton, age 35, and Diana Ruiz, age 43. And, because he received the death sentence following the jury's recommendations that fell short of unanimity. Notably, Wilson is not contesting the guilty verdicts themselves, but is instead disputing the constitutionality of the death penalty imposition under the revised state statutes. Now, the controversy stems from a 2023 amendment to the Florida law, which lowered the threshold for a jury's death recommendation from a unanimous decision to a minimum of 8 votes in favor, with up to 4 jurors dissenting. In Wilson's trial, the jury voted 9-3 for death in Melton's case and 10-2 in Ruiz, prompting the presiding judge to issue the capital sentence for both counts. Well, defense attorney Michael Ufferman, in his filed appeal, contended that applying this legislative change retroactively contravenes provisions in both the U.S. and Florida constitutions. He highlighted a long-standing Florida statute that explicitly bars the backwards application of laws pertaining to criminal offenses or their penalties. At the time of the murders, state law mandated full jury consensus for both death sentences. Now, during oral argument on Thursday, Ufferman declined to restate his written submission, recognizing the Florida Supreme Court's prior affirmation of the 2023 law in a similar case. Instead, he emphasized the need to formally preserve his constitutional claims for potential review by the United States Supreme Court. Now, representing the state, attorney Rick Buckwalter offered minimal rebuttal, stating he had no substantive points to add and urging that the justices should uphold the trial court's ruling. Now, the Florida Supreme Court panel swiftly affirmed the lower court's decision, maintaining Wilson's death sentences. One justice lightheartedly remarked to observers that such hearings are seldom resolved with such efficiency. Well, the development obviously underscores the ongoing debate of retroactive sentencing reforms and their alignment with constitutional protections against ex post facto laws. Wilson's case may now proceed to the federal appellate level proceedings, which obviously has a big influence on the capital punishment standards. And this is an interesting legal issue. Constitution says no ex post facto laws, basically saying we're not going to go back and, ex post facto, go back and redo it. So I think the defense, when it gets to the Supreme Court, may have a very good case. Florida said, nope, we're going to uphold this law. We've done it before, close enough for government work, but I'm not sure that's going to fly. Remember, the Supreme Court has already said you have to have unanimous jury verdicts, because there were still a couple of states, I think it was Louisiana and Oregon, said, well, you didn't have to have a unanimous verdict to reach a verdict. We had the same thing in the military way back when. Only needed 2/3 to convict. So the Supreme Court said, no, you can't do that. So I find it hard to believe the United States Supreme Court would not say, when we're going to impose the ultimate punishment, that there must death. Now, I get the frustration where people are like, really? We got 11 or 10 people that want to do death, and you got one or two that say, no, I just don't do it. I think he's redeemable, whatever. And so it all goes away. So it's a tough balancing act. Why should that one person really have more vote? Their vote mean more because they can in that particular situation. But think about it. If it's not a unanimous verdict, you get a mistrial. Maybe you just have to keep going until you can get a unanimous verdict. Maybe you have to declare a hung jury, basically, as it relates to the death penalty. Something to think about. Next, a Las Vegas educator. Well, could you imagine what he's being arrested for? Oh, yes, that's right. Alleged sexual exploitation of a young 13-year-old student. But, who can really keep love apart? Age is just a number, right? Isn't that what they all say? Well, a 48-year-old mathematics instructor in Las Vegas, previously employed in a middle school in Nampa, Idaho, faces serious charges following his arrest for purportedly engaging in inappropriate electronic communications with a minor. Police from the Las Vegas Metropolitan Police Department detained Brian Conway on February 3rd, charging him with the facilitation of a minor under 14 in producing pornographic material using digital means to lure a child for sexual purposes and possessing visual depictions of pornography involving individuals under the age of 16. Conway has previously served as a teacher at the South Middle School within the Nampa School District. And of course, district officials have confirmed that he voluntarily left his employment during the prior academic year, citing reasons unrelated to the current allegations. Investigators have indicated the potential for additional victims, giving Conway's extensive involvement with young individuals in educational settings. Are you telling me there could be more than one victim in a case like this? You mean he didn't get caught on his first time? You mean he wasn't potentially grooming other students? Oh my goodness, tell me it isn't so. Oh. Well, according to the arrest documents obtained by the local news media there, the incident came to light when the father of the 13-year-old girl reported discovering sexually explicit messages on her mobile devices. The communications allegedly occurred through platforms including Instagram, Signal, and just the good old-fashioned text messages. The girl's mother first became suspicious upon observing late-night texting activity, leading her to inspect the phone and uncover the exchanges with Conway. Upon questioning, the daughter reportedly acknowledged that the interactions had progressed over several months. Grooming, perhaps? The father had initially assumed the after-school sessions were for academic tutoring. Following the report, needless to say, law enforcement executed a search warrant at Conway's residence, confiscating 2 smartphones and 3 laptops, along with other items such as clothing and photographs. During interrogation, Conway invoked his right to counsel, which he certainly can do, and declined to provide any statement regarding his association with the minor. Now, individuals who believe they or someone they know may have been affected by Conway's actions are encouraged to contact the Las Vegas Metropolitan Police Department Sex Assault Detail or Unit for further assistance. These get tricky, ladies and gentlemen. Okay, I get it. 13-year-olds, a little too young. They all think, they're 13 going on 20. They know everything. I know. We've all, if you've ever had a teenager, they know anything, they know everything, but they don't know how dangerous it is out there. All right. I can think of a recent case where a young gentleman was sending out texts to older gentlemen and initiating it clearly. And the inappropriate conduct was inappropriate by everybody involved. And then, the young person would then claim that he was in fear for his safety and his life and things of that nature, which is odd because he was the one initiating all this, and now suddenly he gets caught and he's the victim. So these are weird, all right? Certainly you can't consent with somebody under the age of 16, usually 15 is kind of the cutoff. 13, way too young, exactly right, can't do it. Wrong. You've heard the old saying, 13 will get you life, 13 will get you 20. Yeah, that's what they're talking about, prison. And teachers certainly know better. I mean, they get all the training. I mean, if you didn't know better from common sense in life, 48-year-olds shouldn't be trying to date 13-year-olds. Like that's even anybody that thinks that's okay is not wired correctly. But sometimes these 13-year-olds need to stop doing what they're doing or immediately go report it. So I guess the moral of the story here is that, be a parent to your young adult, teenager, preteen, and not their best friend. All right. And check their phone. They're a juvenile. They have no expectation of privacy in your house. You should be able to see whatever is on their phone at any given time. And if they don't like it, maybe they just shouldn't have that phone or that iPad. All right. And I'm not talking to you as some curmudgeon old man. I'm telling you, as somebody that's done criminal defense for many decades, ladies and gentlemen, be a parent. Don't be your kid's best friend. Check out what's on their phone. Check out what they're doing. It could save their life. I'm telling you. Seen it too often. Too often. Next, how about this day in legal history? February 6th, 1788. I know. Massachusetts becomes the 6th state to ratify the United States Constitution following a closely contested convention vote of 187 to 168. Obviously, that ratification was pivotal in establishing the nation's foundational legal framework, and it helped build momentum towards the Constitution adopted and the required 9-state threshold, ultimately shaping the structure of the federal government and individual rights. On this date, February 6, 1899, the United States Senate ratified the Treaty of Paris, formally concluding the Spanish-American War. The treaty facilitated the secession of territories including Puerto Rico, Guam, and the Philippines to the United States, marking the significant expansion of American jurisdiction and influencing subsequent debates over imperialism, colonial governance, and constitutional authority in foreign affairs. Hey, we won. To the victor go the spoils. That's just the way it is, ladies and gentlemen. And on February 6, 1933, the 20th Amendment of the United States Constitution was proclaimed in effect by the Secretary of State, known as the Lame Duck Amendment. It advanced the start date of presidential and congressional terms to January, thereby shortening the transition period following elections and enhancing the efficiency of governmental operations by reducing the opportunities for outgoing officials to enact unrepresentative policies. That's right. Can't have them looting the treasury. Now can we, ladies and gentlemen? Because let's face it, what are the goals of politicians when they get to office? I don't care either side. Loot the treasury and enrich their friends. I think we've been seeing a lot of that coming out. That's been taking place for years and years, decades. It's time to stop. Next, how about our legal quote of the day? Regarding freedom. But it's not by an attorney. It's by Milton Friedman, the famous economist. So one of Milton Friedman's notable quotes regarding freedom is, quote, "A society that puts equality before freedom will get neither. A society that puts freedom before equality will get a high degree of both," end quote. And finally, our dumb criminal of the day. Now, in the quaint town of Williamsport, Pennsylvania, where family bonds are typically as warm as fresh baked pastries, a recent sibling squabble escalated to law enforcement levels over an unexpectedly contentious confection. Police were dispatched to a local residence on a crisp Monday afternoon to defuse what dispatchers described as an ongoing domestic altercation, mercifully devoid of weapons or inebriation, but brimming with threats of mortal peril. The crux of the conflict, you ask? A lone lamented sticky bun, allegedly devoured by one party without the other's consent. And according to radio transmission, the feuding kin were locked in a verbal barrage, each accusing the other of pastry pilferage and vowing dire retribution. They're threatening to kill each other over who ate the last sticky bun, the call summary noted, transforming simple snack into a Shakespearean tragedy of sibling rivalry. Regrettably, the Williamsport Bureau of Police has rebuffed requests for additional details, leaving the public in suspense about the combatants' ages, names, and any potential custodial consequences. Was anybody arrested? Now, one can only speculate on the bun's provenance, though local whispers of Mr. Sticky's, a nearby emporium renowned for its irresistible cinnamon swirls, crowned with velvetly creamed cheese frosting. And if indeed sourced from the Sticky sanctuary, the treat's allure might explain the heated exchange. After all, few delicacies warrant such familial fury. While domestic disturbances are no trifling affair, this episode serves as a lighthearted reminder that even the sweetest indulgences can sour relations. Perhaps next time, the siblings might consider sharing or stocking up on a few extra sticky buns. All right, ladies and gentlemen, before we go, like I said, can you believe it's already the Battlbox time? We bring in the Battlbox. As you can see, I have no idea what's in the Battlbox. It is still taped from the delivery man, but don't worry. We have our K-bar that, I've had since the summer of 1988 upon graduation from Marine Corps boot camp. That's right, Brian Koberger. I didn't lose mine. It's called responsibility. So let's see. Now, for those who don't know, I don't get paid for this. This is not a paid promotion. This is just something that, I ordered a long time ago, and it comes every month. And literally, it is like Christmas once a month. And I never know what I'm going to get. I'm sure there's something that I could tip myself off to if I read the emails, but I don't. I wait for the surprise. And, it's not as big one today, but we've got the Battlbox instruction book here to see. This is mission 132. So let's see what we got in here first. Clean Freak body wipes. Lemongrass citronella. Staying clean is about skin health, morale, and keeping irrigation from slowing you down. How about irritation, not irrigation? Clean Freak body wipes give you a deep, refreshing clean with zero alcohol and a serious lineup of natural ingredients. You know, when I was back in the military, we would have to go out to the desert. Good old baby wipes, they were worth their weight in gold. Seriously. You spend a couple of days, weeks in the desert, baby wipes are the best thing ever created. And now we got some. Here, we've got some repair tape, tenacious tape, repair tape. And it says, fabric fails at the worst possible times. Tenacious tape repair from Gear Aid is how you solve the problems without ending the trip. This ultra aggressive repair tape bonds to technical fabrics like ripstop nylon and polyester, creating a weatherproof, long-lasting fix. There you go. Never know you needed that until you didn't need it. Ooh, look at this. We have a stool. The Grand Trunk Compass 360 swivel stool. Sometimes the best move is to stop moving. The Grand Trunk Compass 360 stool gives you a stable padded seat that rotates smoothly in every direction. Where was this when I needed it when I was detailing Crime Talk 1 last week? How about this? A compass. Everybody needs a compass, ladies and gentlemen. Everybody needs to know how to use a compass. You know, if you don't know where you are, now here in Colorado, we always know where we are because we got the mountains to the west. But let's say you didn't know where the mountains were to the west, right? Or the north even, perhaps. There you go. Everybody should have a compass. Throw it in your little go bag for sure. Oh, this is something big. Let's see. This is the, actually, let's do this. This is the Wazoo Everyday Gear Wild Compatibility. It's a fire card, proves that fire starting doesn't need to be bulky, waterproof, burnable, and ultra thin. Seriously, ladies and gentlemen, you always need to be able to start fire. So let's see what this is. It helps to start fire, but let's see. It's like the size of a credit card. Walled size, waterproof, weatherproof, resistance. Scrape edge of the card to make a coin-sized pile of shavings. Spark, lay the card corner on shavings and ignite or simply touch card to an open flame. Brace yourself for 30 seconds of intense burnage. Okay, well, it helps get the old fire going, but you need a little flame to get it going. It'd be a little more interesting, I guess, if it included a flame in its fire starter. But hey, you can't have it all, right? Next, what is this? This is the Dark Energy Spectra solar panel. Wow, we just got one of those as well. But look, it actually fits on the back of like a backpack. Look at that. Look at that. Outlets don't exist where you're headed. The Dark Energy Spectra 8-watt solar panel keeps your gear charged anywhere the sun shows up. The ultra lightweight at just over 9 ounces and built with armor flex protection, handles raindrops, pressure, and rough conditions without quitting. USB A and C outputs, a built-in sun meter, flexible photo skin cells, and IPX7 waterproofing. Oh man, let's see. You never know when you need the knife though to check it out. Let's just take a quick look at this because you never know. We're heading into the weekend. I don't know about you, but I have a lot of work to do yet. But I don't really feel about it, so let's mess with the Battlbox because, you know, we can. Ooh, look at this. Look at how tiny it is. It looks like it folds in two here. Snaps. Look at that. Ta-da! I guess these are the plugins, and here's the plugins, right? You put it out there, you can plug it in. Who knows, Frank? You never know when you may need portable solar charger thing. And of course, okay, so this actually has it, see? So you scrape the card, but then you light it. No. Looks like you can. Hesitation. All right, well, we'll take a look at that. So you scrape it. Yep, you got to scrape the card. You spark it. Yeah, we need spark. And you start it. Well, I guess you never know. If you don't have anything around, you got to do what you got to do. And let's see what the knife is today because, well, you know, when you get the big box, you always get something sharp in it at the end of the day. I probably have more sharp objects than I know what to do with, but that is okay. We'll take it. One of these days, we're going to have like a yard sale out at the hangar. Actually, it'll be just a free shopping. Come for your Battlbox shipping. Oh, got another knife. We're going to have to throw into the box out there. Let's take a look at it, because you never know when you need more knives, ladies and gentlemen. Oh, that's actually the strap there. This is the only one. Oh, look at that. Looks like a little meat cleaver kind of thing, but it's sharp. Never know when you may need it. Sure, if you walk with this on somewhere, it would get somebody's attention, and they may come to talk with you. All right, ladies and gentlemen, that's all we have for today. Hope you enjoyed the show. Have a wonderful weekend. We'll see you next time. And yeah, that's right, the Constitution matters.